Welcome. Hi. Thank you so much for coming. My name's Suzann Moskowitz. I'm an attorney that practices in intellectual property and technology. I have my own firm, like many of you in the room. I'm an entrepreneur. Raise your hand. Are you an entrepreneur? All right. Yes. I quit a big firm. I decided it would be more fun to work more directly with my clients, and that's what I've been doing for the last few years. So today's presentation, like I said, very trying to keep it really casual, really informal. Please feel free if you have questions while I'm going. Feel free to interrupt me, raise your hand. Certain things I may push you off to the end because I'll be sticking around all day and I don't want to get too off track. I'm covering a lot of topics today: trademark, copyright, privacy, new mobile and children's privacy. There's absolutely no way that we're going to learn every single thing about these topics today, but I'm trying to give you a flavor of a lot of these things, and I promise I'll stick around and I'll answer your very specific questions if I can. But even though I'm a lawyer, I'm not your lawyer, so I can't, this is not legal advice, but hopefully something that'll be helpful for you and your business. So thank you for coming. So why don't I get started? The conversation is really in two parts. The first is intellectual property opportunities, and I really do call them opportunities because they are opportunities to build value, although obviously there's challenges too with that. And privacy protections, a huge area that in 2013 there's already been a lot of regulatory action, and I want to alert you to some of the things that may impact your businesses. Within intellectual property, there's a lot going on. Patents and trade secrets I've put to the side because I'm not going to really talk about those areas. I can answer some. I'm not a patent lawyer, but I can answer some questions. Typically with software, the area is very much in flux in terms of patent protection. But if you tell me about your situation, that's something I can direct you if patenting might be the way to go. Some of you may have seen the Square Shooter's presentation. In his case, he had something that it was patent protection was really valuable for, but not in every case for software. Trade secrets really just have to do with keeping things confidential, and if you do have something that is a secret, that your company treats it as a secret. Otherwise, it loses its protection under state law as a trade secret. But I'm going to really focus in a little bit more today on these main areas of intellectual property law. First, the idea of a trade name. A trade name is not an intellectual property right. It's a company name. So Jeremy's company, Candelabra Studio LLC, that's the name that he uses when he goes to the bank, but it's not an intellectual property right and shouldn't be confused with it. A copyright has to do with actual creative works. Many things in this room, on this screen, are available. Copyright protection is automatically available to them, and registration, as we can talk about, is something that they're entitled to. So the photo for the poster for Call of Duty, the entire text of the book, any Dummies book, a sculpture, software code, anything that's a creative work is a copyright, a complete work. And that's not to be confused with trademarks and trade dress. Trademarks and trade dress, that's branding. That has to do with how you package your company. Whether it's, so not to be confused with Candelabra Studio LLC, which is just a trade name for Jeremy's company. He's got this logo, the hand, and he's got the little R in a circle because with my help, he registered it at the U.S. Patent and Trademark Office, the USPTO. We'll be talking a lot about the USPTO. He registered the hand logo on its own with no words. He registered the words Candelabra Studio to be used as a brand. And we'll talk a little bit about the benefits of protection of these brands. But a subset of trademark is trade dress. Does anybody know what package this is? This is a store's package. What store? That's right. So the Apple Store has registered and received protection for the look and feel of its stores. A lot of restaurants do this too. Chipotle's done this as well. So trademarks cannot just be the logo, but a physical package, a bottle, a shape of Coca-Cola. We'll talk a little bit more about trademarks. So why be here? Why even think about your intellectual property? Many reasons. Here are a few. First one, that I really focus on is retaining the existing value. So you've built up this brand, and you don't want some nefarious person out there to free ride on the hard work that you've done and to try to come up with something that's a little bit similar to your brand and take away from your success. By having a registration, which is a formal way of protecting a brand, it's like having an insurance policy. You do not need to insure your home or your car. Well, you need some car insurance, but you basically don't need a high level. It's not mandatory. But by having these registrations, you get certain benefits. This is true in both the world of trademark and the world of copyright. You get things like statutory damages. That means you don't have to prove that you were harmed if somebody copies you or tries to confuse people a little bit about the origin of their goods. It means that you just go to court and you say, listen, I had the registration. And it gives you a huge advantage. It gets your attorney's fees paid for if you have to fight. Now, you don't want to fight, but if you don't have these registrations, it's probably not cost effective. A lot of people just say, oh, I guess I'm going to tolerate this. A number of other benefits that work like an insurance policy. And as you'll see, the cost of doing so isn't so crazy. Besides that, besides the insurance policy benefit, there's building new value. When you have your intellectual property, you have these brands, you have your logos, you have the eagle, as Jeremy was discussing, you have the hand symbol. These are part of your, especially when you don't have a factory that builds widgets, you don't have a bunch of inventory. You just have soft IP. You have these concepts that could be worth something. And if, let's say, you want to sell your company and somebody's inventorying it, you have an accountant take a look at it, this actually adds value, having these registrations. Also, if somebody wants to just invest in your company. So for a sale or investor, these are huge things for them to see, actual registrations. And heartbreak. When people name a company or name a product or put together a creative work, it's your baby, and nobody wants to have to get into a fight with somebody else about taking the name or their logo or copying your code. Having these registrations helps you protect your baby and not have to make huge changes to what your dream was. So let's focus on copyright. That C in a circle, by the way, you can use whether or not you register a copyright. It's a little different in the trademark world, but anytime you put together a document, a poster, a web page, it should say copyright, C in a circle, the year, and your name. You don't have to have that, but it's a way of demonstrating how serious you are as owner of that content. So we're going to go through a few things with copyright, a little bit about the process, some pitfalls, some misunderstandings people have about copyright. Fair use is a big one. And we'll talk a little bit about contracting and copyrights, the employment relationships, the concept of work made for hire. And again, it's a lot of material, so as we go through, feel free to ask any questions, but some of it I may kind of put to the end. Copyright. So anything that's an original work of authorship is eligible for copyright. It has to be more than just a couple of words. A short slogan can't be copyrighted. A short poem can't be copyrighted. But something that has some level of creativity. Here's an example. This is from Uncle Slam, Jeremy's software, and this is his website, which is like a promotional newsletter, the Gazette. It's highly creative. It has so many elements here that if somebody came up with a similar piece of software and ripped off this concept, it would be really infringing on his copyright. Now, Jeremy hasn't registered this copyright. He could, and it's an example of there's so much copyrighted material that we do. It's almost hard to prioritize what should actually be registered. But we'll talk about the process and how to prioritize. There's also copyright for things that I don't think are necessarily as creative. Sometimes I like to pick on brands that annoy me, and here's one, Lululemon. This bag is filled with a lot of trite quotations and supposedly inspirational things. It's still eligible for copyright protection, the design of the bag. as well as all the words that are on it. This bag also has something that's a trademark, which is the name on the side. This is not a typical sculpture, but it is a work of art, and it also would be eligible for copyright protection. We could go on and on with those examples. These things are all considered expressions. Let's draw a distinction between expressions and ideas, because you cannot protect an idea. I get a lot of phone calls from people who say, I have a great idea, how do I protect it? And it's difficult because there are so many different ways to express ideas that if we protected every single idea, we would impede innovation in a way. So here's an idea. This is the idea of a tetraploid game, the idea of nesting boxes, also known as Tetris, a very well-known trademark. As you may know, when you go to an app store of some kind, there's lots of games that have this idea. Tetris cannot sue every single one of them. But if it's exactly the same, if it's substantially similar in look and feel, then they may have a case. We'll also talk about how they may not have a case, but because they're associated with a big company, they're a little bit of a bully. And sometimes bullies make innovators and entrepreneurs go away unfairly. So this is an idea, not an expression per se. Well, this is one expression of the idea, but that's the difference. So, like I said, copyright's automatically created. As soon as you put pen to paper, type some words, paint some strokes, it's copyright. You don't have to register it. You don't have to put that copyright notice on it either. One of the reasons for notice is that if somebody does copy you and you take it to court, if you have the notice on it instead of not having the notice, the judge looks at it and says, oh, this wasn't just copying. This was like somebody who knew that this was copyrighted material and they're, a dirty jerk, and maybe your benefit, your kind of monetary compensation for it happening might be higher for the bad faith because they knew that they were copying. Registration, also not required. But registration is a pretty simple process. Can be done without a lawyer, just like trademark registration. Both the U.S. Copyright Office and the Trademark Office have some really good websites, really good tutorials you can walk through. Not only is it easy, but it's pretty cheap, relatively. You can get your whole website. You can get a collection of images. You can get a wonderful sculpture all registered for $35. And once you do one registration, easy to just take your form and do them over and over again. It's a great value. Whether or not you register, being the owner of a copyright gives you exclusive rights. So that means that if you wrote a song, you not only have the right to own that song, to perform that song, to write that song down, you're also the one that has the rights to make changes to the song, the idea of a derivative work. You are the one who can take a portion of the song and make a video of it. Other people are not entitled to those things automatically, unless, of course, you make an exception. Sometimes people explicitly give up some of their exclusive rights. In fact, it happens all the time. We talked about this in the area of square shooters. He received a license to do what he did with square shooters. We see license agreements all the time. So this is a typical copyright license agreement, a click-wrap agreement. This is from an IBM software. But there's also the idea of copyleft, some more permissive licenses. That's the Linux model. Or if any of you are familiar with Creative Commons, can you raise your hand if you're familiar? I can talk a little bit about Creative Commons. Okay, great. Yeah, a great place for images and for materials that people decided. Yeah, I created this. And I know under regular copyright law, I should be the exclusive rights holder, but I believe in the copyleft concept. I believe that share and share alike, and maybe we can all build something bigger. And if I'm revealing my own biases, that's because I think it's a great idea. But I also believe that people who work hard to develop a piece of software, or a singer that works very hard to make their name, should also be paid for what they do. So I like the flexibility of these models. Does anyone know what this is? This is the comet. The comet's coming. Look, today. This picture is something that someone let me use. The government, NASA. I'm totally allowed to use this picture, unlike most of the pictures in my presentation. We'll talk a little bit about the risks I'm taking and the licenses that I'm violating. And this is being recorded, but I'm not really violating any licenses. It's all fair use, I'm sure. But we'll talk about that. So the U.S. government, in addition to Creative Commons, taking materials that are owned by the U.S. government are almost always in the public domain. But we have to be careful, because don't assume something's in the public domain. Beware of things that are free. I'm sure you all are sophisticated and know that just because you can copy and paste images from the internet does not mean you should take those images and put them into your works. I'm sure you all already know that. But sometimes things look free, and sometimes there's websites called freeimages.com. You still need to read the license agreements, because a lot of times things that are free are only free for non-commercial use. Are any of your businesses non-commercial? Probably not. And neither is mine. So when I give this talk, even though I'm not paid to give this talk, it's commercial use. There's no question about it. Beware. Fair use. Who's heard of fair use? Yes. Fair use, lots of fun, really confusing. Fair use considers these 4 factors. There's no formulas. It's a balancing test. And we're looking at, I'm going to show you, I'm not going to read this because I'm going to show you a simplified way to think about fair use. But in a nutshell, fair use is when somebody wants to take something, and I'm going to do a little multimedia here to give you an example. You take something and take a little piece of it maybe and put it in what you're working on, because you think it's just a small piece of it and no one will see it anyhow, or it's such a small part relative to the whole, or there's no way that the owner of this is losing any money because of what I did. And we make a judgment about if this is okay to include in our presentations. So some people want to have some formulas, and I say beware of formulas. If you go on the internet and you search, you want, is this fair use? People have tried to make formulas. Here's one. Ignore it for 2 reasons. One is because I borrowed it from somebody on the internet, so we definitely don't want to copy this again. And 2, because it's not accurate, because there's no way to quantify it. This is the way I like to look at it. You think about the type of use. Is your use commercial? In most cases, in all my clients, it's going to be commercial. It's very few situations where the question is really academic. But let me be clear. Nonprofits and academics, there is no free exception. There's no blanket exception for those kind of things. It's just one factor. It's an important factor, but it's just one factor. Another thing is the nature of the actual original work. Is it factual? If you're doing a scientific work, there's only a few ways to convey something that's numerical or scientific. You have a little more leeway with those things. You have much less leeway when we're talking about fiction versus nonfiction. The oomph, that's the substantiality of the portion. Sometimes you have a song that's 12 minutes and just the chorus, just 12 seconds of it is enough that's substantial, because you're taking the heart of the work. Let's say there's a book, and there's a kind of a famous case in copyright fair use where there was a book about a president, and the part that was taken, there was an excerpt that was taken and published in a magazine, but it was like the best part of the book. It was like the most exciting chapter. And because of that, even though it was only a few pages, that was not fair use. So that's the oomph that I'm talking about. And the courts are very sensitive about this last one, whether it's a replacement. Does it actually take away the money that the original owner would have made? Does it replace the original work? And not just the original work, but possible expansions. So Harry Potter, lots of books, lots of derivative works of those books. Some are fair use, some aren't. There was a big case, somebody who did a kind of a Harry Potter compendium where it was like a dictionary, and it was this tool to use with your Harry Potter books. And of course, J.K. Rowling was outraged, and it was a huge case. And what they determined was, even though, no, it's not it's not a fiction book that replaces a book she would write. It wasn't even a copy of one of her books. But it was within the possible expansion of what she would do. And because of that, it was not considered fair use. I can try to answer some fair use questions if you have any now, or I'm going to keep going. Just raise your hand at any time. I know fair use is tricky. This was an interesting case of the Hope poster. Now, obviously, this is a work of art. This started from an Associated Press photo, and people love this image. And somehow it's been associated with Obama and Hope and all kinds of positive things. But the truth behind this image was the person who developed this image took a photo from Associated Press, lied about where the photo came from, tried to delete the files on his computer, went through a long court process, and now was personally liable for over $1 million, which he actually paid. Plus, he has about hundreds of hours of community service. This all ended this fall. The fact of the matter is, it's a dangerous territory trying to take images when Associated Press and everybody else who owns images now, everybody knows with a free thing like Google image search or something more advanced, it's very easy to find the images you own. And if somebody else who takes your image puts it online, it's likely you're going to get caught. So I don't mean to be overly conservative about this. There are ways to use images, pay a license fee, and there's fair use. But this use wasn't fair because this was a commercial use. He didn't change it enough. And the fact that he lied and covered up didn't really work in his favor either. This is where my presentation goes multimedia. Excuse me. I decided we needed a little bit of musical entertainment, and there's a band called the Speed Bumps out of Kent. And they're very good. And I thought I'd use this opportunity just to give you a little break so you can hear a little music. 1, 2, 3, 4, 5, 6. Fair use? What do you guys think? I didn't ask for permission. Why do you think it was fair use? Can I put you on the spot? It was pretty short. I was trying to prove a point. I only did 6 seconds. But don't be fooled. There's no 6-second rule. No way. Not even close. So it was dangerous that I did that. And this presentation, if it ends up on the internet, maybe somehow they'll hear, I used a portion of when you hear about all those cases of the background music. Yes? Mm-hmm. And at the same time, you actually gave them a little. That's right. Oh, yeah. And here's their album cover. I'm definitely trying to promote them. I'm going to give them credit, but giving somebody credit, that's not a cure-all either. It's a factor that's considered in connection with your good faith, because bad faith, as we know, in deleting files gets you, $1 million penalties. I think it was fair use, actually. But had I played background music for my whole presentation, probably wouldn't have been cool. I probably should have paid them some kind of license fee. So every single situation requires consideration. And the truth of the matter is, you can pay a lawyer $1 million to try to give you a risk assessment about this. You're never going to get a guarantee, because the fact of the matter is, so many situations I'm involved with are just about human relations and who decides to get mad and who decides to be cool. Speed bumps are cool, though. You should listen to them. Thank you. Okay. This is one of my favorite quotes from one of my favorite professors that I had in my law school, Larry Lessig. Fair use is not the right to use copyrighted materials. It's the right to hire a lawyer. It's a complicated area, and I urge you to proceed with caution. I want to do a quick note on another area in copyright, and that's work for hire. Have any of you ever been presented with or presented somebody with an agreement that involved work made for hire? Yeah, some of you in the room. Okay, so any of you actually somebody's employee right now? Okay, all right. I used to be somebody's employee. I'm not anymore. It's okay. It's cool to be an employee. So the default rule is anything you create in the scope of work, they're going to own. Okay, unless you make some very specific arrangement in writing, your employer owns it. There was a big case, the person who invented Bratz dolls was actually working for making Barbies at the time, and when he had the idea about Bratz dolls. And that's another case where somebody had all these files on his work computer and then tried to delete them. And when the court looked into this, they saw the deletion. So bad faith. But let's say you're an independent contractor working for a company or working for an individual. In that case, if you don't have a written agreement, the rule is the contractor owns it. So I see a lot of handshake agreements. Any of you involved in any handshake agreements right now? Nothing on paper? Oh, one person only, good. Well, a handshake, if you're the contractor, you're in a good position. If you're the person who hired somebody to do a project for you, not a great idea. So just keep in mind that these are the defaults under copyright law. It's really important to get the language in. And if you're going to have an agreement, there are a few kind of magic words in copyright law. The concept of work made for hire is complicated. I'm not going to get into it right now, but if anybody has any questions after, we can talk about that. There's some simple language that will protect you. Let's move to trademarks. First, can I answer any copyright questions before we move to? Okay. Trademarks. That's the registered symbol. Unlike the copyright registration symbol, do not use this symbol unless you have a federal registration. It will be false marking. You will get your hand slapped. Don't do it. But you can use TM, and I encourage you to use TM. Even if you never intend to file anything, if you call it your brand, you can use TM. You don't have to put the TM on every single occurrence of what you do, but get it on once every web page or once every poster. Again, it shows that you're serious about your intellectual property rights. In our section about trademarks and branding, we're going to talk a little bit about the benefits, the process, the strategy, what happens when you're rejected, and trademark fair use, which also exists. So here are some examples of trademarks. We can have words on their own. They can be simple words. They can be full slogans like Jeremy's "Don't forget to play" for GAME.minder. They can be stylized words like Halo. They can be in color. They can be in black and white. They can have no words. They can be a product configuration like a store configuration like the Apple Store we saw before. But it can be the box of Toblerone. It can be the shape of the chocolate inside. All of those are protected marks. Those file folders, those are protected because they smell. You can actually register fragrances as long as you can't register a perfume because it's supposed to smell. That's the utility of perfume. But a file folder is probably not supposed to smell. So the idea is that Avery Dennison says, oh, if you smell a peach file folder, you will think of Avery Dennison. I don't think, that went so far, for their business, but it's a protection that they have. So why focus on your trademarks? Well, if you have a registration, it helps you get a brand monopoly. If someone else comes in, and not even just with an identical mark, and not even with identical goods, if they come in and it's close, the standard is likelihood of confusion. And if somebody creates a kind of slightly confusing situation, by having that registration, you have a lot of leverage. You've got that insurance policy. And you can use that to maintain your monopoly. And monopolies aren't always so bad when you're trying to build a brand. The other thing is accounting value. I talked about that before too. One day your business is going to grow so big that someone's going to want to take a look at your books and take a look at all of your intellectual property, and it's nice to have some things registered. This is the place, USPTO. Again, you can do it yourself. This process helps to have a lawyer. You don't need to have a lawyer. A lot of the situations I'm involved with, people file on their own first, and then they get an office action, which is an initial rejection, and then I help clean it up. But absolutely no requirement to have a lawyer for either of these. The filing fee is higher, but the protection is a bit broader, and it's still, for an insurance policy, I would say very good value relative to the cost of fighting infringement when you don't have a registration. One point about domain names. People seem to think, or many people that I talk to seem to think that if the domain name is available, the trademark is available to them. Domain name strategy is extremely important. For clients of mine that come up with their name before they think about domain names, they often end up in a sad situation where they're forced to pay a lot more for a domain name because somebody else is holding it. So instead of getting a $8.99 domain name, they're getting an $8,000 domain name. So domain name strategy is important, but there's nothing about domain names that has anything to do with trademark availability. On the flip side, if you're an intellectual property rights holder and somebody comes in with a domain name that's similar to your mark, well, there's a basis for a challenge. But don't be fooled into thinking availability of domain names is going to cover you. When choosing a brand, there's a few things that I tell a client. One thing that we'll talk a little bit about is, who else is out there? And that's looking at the third parties and the likelihood of confusion. But besides, put third parties out of your mind right now. Pretend that you're the only person in the world who's come up with your brand. The USPTO also makes a big business of rejecting marks because they think that they're too descriptive. A mark has to be creative enough. It just seems unfair to give somebody who wants to call cola, a monopoly. You need to be more creative. So this is the spectrum. As you can see, if you want to call your cola, exclamation point, it will be rejected as generic. There is no way to get that protected. If you go into the area of Fizzy Pop, Cleveland Cola, they don't really like those. They're not really that descriptive. They'll say to you, there's a lot of people out there who call cola Fizzy Pop. Prove to us that that's creative enough. And you can make an argument for it. One thing you can do for a descriptive mark in the yellow is if you're so committed to using a mark like that, is you can wait 5 years. You can be on this kind of B list called the supplemental register. And then after 5 years, or if your product becomes so popular quickly, you can even graduate sooner. And then after 5 years, you say, see, we're still in business. We're very famous now. Then you get to be a fully registered mark on the primary register, principal trademark register. And the green are the best ones. A mark that's suggestive. Wired is suggestive of caffeine. An arbitrary mark is a real word, but used in an arbitrary way. There's no real reason to call your cola Amazon, but you can. And coined is a made-up word, like Pepsi. So again, you want to move in this direction when you're thinking. But that's, easier said than done when you want people to know what it is that you're selling. Jeremy, again, I'm using Jeremy as my example because he said it's okay. And look, he's right there. Jeremy has a great portfolio of suggestive marks. There's everything about these marks tells you, and I would say of these marks, the one that's the closest to generic is GAME.minder because it's more specifically, minding hairstyles. But everything else here, it requires kind of a mental leap between what it is and what the name is. But what if he would have just wanted to call it, reminder, re.minder, if he just wanted to call it reminder? It absolutely would have been rejected. So he made a small difference, but that difference got him registrability. But I call it the descriptiveness paradox. And the example that comes to mind is chocolate laxatives. If you don't tell people what it is you're selling and it's in the wrong aisle, someone gets confused, it could lead to trouble. You need to at least suggest the lax part of it. So I understand when business owners come to me with something that's really descriptive and they really want to use that name. But if it's not going to be registered, you leave a lot of protection, you leave the insurance benefits, you leave that accounting value on the table. Apple has been fighting this one for about 5 years. It seems like they've finally given up. They really wanted this to be their own mark. Are you guys familiar with the concept of multi-touch? The USPTO absolutely wouldn't have it. They just said there's multi-touch is just too generic for what they do. It's something that they probably spent easy high 5 figures fighting this one. It would have been better if they came up with something a little more creative from the beginning. Likelihood of confusion, so going back to that. Let's go back to a world where there are other people with companies. So the descriptiveness world is just you versus the USPTO. The likelihood of confusion world has to do with, is there someone else out there who's using a mark that's similar? We don't just look at the similarity of the mark. Obviously, there's a United Airlines, there's a United Van Lines. You can have the same mark for different goods. There's also different trade channels. If there's a product that somebody buys at the grocery store, versus something that somebody only buys for their business and downloads it online, obviously those trade channels are very different. So there's a lot of factors that are considered by the USPTO when they look at the possibility that you'll be confused with another mark. When you do apply to register, the USPTO does not get on Google and look who else is out there. They only look at who else has registered their marks. But when I work with a client, or any attorney works with a client, or when the client does their own due diligence, you need to look at what else is out there, because even if you don't have a USPTO strategy, even if you're not going after that insurance policy, you still want to make sure that you're not stepping on someone's toes, because it could come up later, and it certainly has for people that I've worked with. So one thing, the USPTO does not look at those last two, the litigiousness, the resources. That's something that an attorney does. Let's say somebody has a new mark and they're really excited, it's a reminder, and we find something out there that's not in the USPTO database, or is, but it doesn't, we're not sure that the USPTO would reject it, but we're still thinking it could be a problem. We do a little bit of investigation. Who's the company behind it? What law firm did they use to register it? How much money does it seem like these people would put into a fight? So it's a little bit of strategy that we use, because sometimes you want to take a more aggressive approach. I, as an attorney, don't want to tell somebody that they reject every single brand that they want to use. But the field is crowded now. You come to me with a mark, and chances are I'm going to come back to you after maybe I'll spend an hour poking around doing what we call a knockout search. And I'm going to say, I found these 3 things. Let's talk about it. Because there's just a lot of stuff out there these days, especially because it's so easy to find through search engines. So likelihood of confusion needs to be considered when you go into branding. Here's an example. Remember, we talked about this from the copyright perspective, the idea of these Tetramino games. Here's a Tetramino game called Tris. And Tris sure looks like Tetris. The name doesn't sound so much like Tetris. Tetris did not like Tris. Sounds a little bit close. Not exactly the same name. Not exactly the same game, but pretty close. But this one never went to court. Why not? Because the developer, didn't want to fight it. And that's what happens. There's a lot of bulldozing, a lot of bullying, a lot of fights that people could win, but don't, because there's bullies on the other side. And that's, if one lesson to take away from my talk is not everything's black and white in law because of these unfair fights that people are forced into. That's why a lot of brands and a lot of creative works and a lot of interesting derivative works and uses of other creative works in your own creative works don't happen, because of that risk, because of that fear, because of that cost. And it's a shame. Killer versus killer. I'm giving you this example because I want to show you what a USPTO search page looks like. You'll get the name, you'll find out what the description is, the filing date. This is when I'm doing these knockout searches, I look through the USPTO. Now, Super Nintendo had a game called Killer Instinct that they wanted to register, and Actually, it had to do with a renewal, but we don't need to get into the technicalities. Let's just say we're killer versus killer. This mark for entertainment services in the nature of a television series, let me zoom in here, I think there was a show on CBS. It was filed in 2005. The show was maybe on one season, but they got their registration, and a registration is good, at least for the first 6 years until you show continued use. So because of this registration, the video game was not allowed to proceed. That sound fair? It didn't seem very fair, especially since that game wasn't on anymore. So eventually this initial one was rejected, but they came back. They demonstrated that TV show wasn't on anymore. They didn't have continued rights, and they were able to proceed with registration. Here's one. It's called Flash Boy, something you plug into your USB drive. Here's a description. It's some interactive games, virtual reality, and handheld units, video game machines. What do you think? Flash Boy. Can you think of anybody who might have a problem with the mark Flash Boy? Who? DC Comics. Oh, that's a good one. Well, that's not the one that came up in this case, but yeah, that's a good one too. What? Nintendo for Game Boys. Yeah, so Nintendo was the reason this one was rejected was because of Game Boy. But again, this is a fight that some companies will go to the appeal board, will go to court, but if you want to be more conservative and you want to spend less on protecting your IP, come up with something more creative from the beginning. This is an example that it came up in the context of a trademark infringement. This is a screenshot from, does anybody know? Which game? Sorry? Grand Theft Auto, yes. GTA, sorry. I know games, but probably not as well as you guys to know the acronym. Yes, Grand Theft Auto. There was a real place in California called the Playpen. It didn't look exactly like this, but there were some things I've never been there, but there's some things maybe about the awning, about the sign, but not exactly the architecture of the building. Well, the Playpen wasn't happy about this, and they tried to raise this as a trademark infringement issue. But it went nowhere. This was considered fair use. This was considered First Amendment. But as you know, and you've probably seen, people use real sports players in their game, real buildings in their games, and also real brands in their games. And when I say games, I also mean in their websites, in their shows, in their books, things like that. And typically that's fair use. In trademark law, there's this concept of nominative fair use. It means you're just naming something. You're not saying anything bad about it. You're not trying to sell something competitive to it. You're just naming it. And in most cases, that's perfectly fine. However, in this world of fear and risk, most people still ask for permission or get a license. And in this example, this is a game called Battlefield 3. And in Battlefield 3, Electronic Arts wanted authentic, and in all the Battlefields, they've wanted authentic helicopters. Well, this is exactly an image of a Bell helicopter, and they're still fighting about this one. They came to agreements about in previous versions of the game, but Electronic Arts is fighting tooth and nail to keep these helicopters in as nominative fair use, and we'll see which. But Bell keeps fighting it because they want to be compensated for it. So we talked about likelihood of confusion. We talked about descriptiveness rejections, but there's lots of other reasons the USPTO might say, forget it, to what you're trying to file. One is, these are real ones. Actually, the first one's a real one. The Quran for wine, that's considered scandalous. It might upset some people, and so they don't want to put, the government behind it. They also, I have a client, F-bomb. And F is, of course, feminism. But there's been an F-bomb, they got their registration, no problem. But there's plenty of filings that have the letter F, which is, ambiguous, that are rejected. And that's a good example of dealing with human beings at the USPTO and their whims about what's offensive and what's not offensive. And two, misleading. Napa Valley wine, turns out it's grown in Parma. Now, if it was really grown in Napa Valley, that would be fine. But because it's grown in a backyard or behind in a back alley in Parma, it's misleading. It's called deceptively misdescriptive, geographically deceptively misdescriptive, and it's not okay, and it can't be registered at the USPTO. That kind of concludes the part about intellectual property rights, and I'm going to move on to privacy. But do I have any questions? I'm just looking at the time. Any questions about trademark or copyright before I move to privacy? Okay, privacy. This is a very hot area right now. Some of you may know that just this week, our friends at Google, by collecting information when driving by people's houses, that case finally ended and they had a $7 million fine, which is, not that cost of doing business for them. $7 million fine may not be something that's in your budget for your company right now. So, privacy. Controlling PII, personally identifiable information. There's lots of reasons to collect personally identifiable information in your games. You want to customize it. You want to be able to analyze your use. You want to make it more efficient so that when people come back, it's easy. The game recognizes them and can help them. There's nothing inherently wrong with using people's information. It's pretty helpful. I like it when people use my personal information. Thanks. But it's a trade-off, and Google keeps getting in trouble. Facebook keeps getting in trouble. One example of recent enforcement action with, I'll get to one of the Google enforcement actions, but let me give you kind of the big picture about privacy law in the U.S. There isn't this omnibus privacy law. There's healthcare privacy, HIPAA. There's financial privacy, that's Gramm-Leach-Bliley. There's children's privacy, which we will talk about a little bit, COPA. And there's a few other regulatory privacy schemes. But there's no overall privacy law. However, the Federal Trade Commission gets involved because Federal Trade Commission is in charge of things that are unfair and deceptive. And privacy violations are considered unfair. One state that drives how we advise clients to proceed with privacy is California. They're always on the leading edge. They're always more conservative. In a way, they're more conservative, you could say. They allow a lot of things, but in the case of privacy, the Attorney General has gotten very involved and requires things other states don't require. And you may say, great, I'm not in California, we're in Ohio. No. If you have a user in California or you ever want to have a user in California, you have to pay attention to California's privacy law. California is not the only state that's involved. Massachusetts, New Jersey, they're all getting on board, and probably more states will too until there's a federal privacy law. So because California says you need to have a privacy policy if you're collecting personally identifiable information, and of course we'll talk about what PII is, because California says it, and if you want to have a user in California and you don't want to have enforcement action taken against you by the Attorney General of California, you pay attention. So I'm not going to read through all of this. You can take a look at it, and certainly after my presentation, I'm happy to share notes with anyone too. I know some of you are taking notes. But California, in addition to having these privacy laws in place for a while, they've come in this year. Already 2013 has been a big year for changes in privacy law. And they've come in and they've been very specific about mobile applications and said, in addition to even having to have the privacy policy, that you need to limit what you collect. You need to collect only what you need to actually function the app as described. No extra information. You need to have controls within the app, not just on the website where people sign up for it or something in connection offline within the app. And if something is unexpected, people would be surprised to know that there's geolocation information collected for a site that doesn't seem to use it, then you need to tell them. That's California. Now FTC, now this is federal, has updated its privacy laws to be clear. This is actually a set of best practices at this point, but the FTC under its unfairness rule, can take enforcement action if they think that you've reached this level of unfairness. And we'll give some examples of enforcement action. But it's critical right now to build privacy into your software. That's the idea of privacy by design. Not taking any more information than you need, making sure safeguards are built into your software, that the opt-outs are easy to find, that if you make a promise, you keep it. And that's a really important thing I tell my clients when they're writing privacy policies. You don't need a long privacy policy. You just need to know what it says. Don't just rip off some privacy policy that you just skimmed. Every word of that privacy policy is a promise. You don't have to make these promises because there's no standard rule about what promises have to be made. But if you're going to make a promise in writing and you break it, you're going to be potentially subject to enforcement action. And now you may be thinking, well, how would it happen that they would pick me out in Ohio making this game? All it takes is, one person at FTC with a kid sitting at an iPad playing a game. The parent looks over their shoulder and says, "What is this?" That's the root of an enforcement action. So these new mobile privacy best practices, if you go to FTC's website, they have some really good user-friendly materials you can read about that are really written for developers, and I encourage you to do so. The data security part is a big part of it if you are keeping information, and you can read those standards for data protection. But again, making sure that not only do you limit what you're collecting, but you dispose of it carefully. This is the Google Buzz case. Anybody remember Google Buzz? Remember that day that all of your employees and everybody that you sent one email to became your friends for a day on Google Buzz and had access to some of your information? This was a big one for the FTC because of this unfairness rule. The Google Omnibus privacy policy says that they're not going to use information in a manner that's different from how it was collected without your consent. But then they went and they launched Google Buzz, which did exactly that, a clear violation, and settled with the FTC on that. And now the FTC is watching them, as you know, very closely, as is the European Union, as is the California Attorney General. So they came in with some additional best practices. These are the real changes. They're very focused now. Just because they're focused on what the platforms do and the platforms building in privacy, ease of privacy, does not mean that that developers are off the hook. Things like the just-in-time disclosures, telling people as you take geolocation information, the FTC wants those platform providers to kind of be responsible for that, but they still say that the developers are going to have to keep an eye out for that too. The privacy policy should be available at the App Store. It doesn't have to be, but that's the best practice right now, and that's where the law is moving. So I recommend that if you're collecting any personal information, that you are making that privacy available at the download page, not only after you download it. They've emphasized the importance that if you're using a third party, like an ad network, that you don't just say, oh, it's them and they're responsible for what they collect. You, as a developer, are working with the ad network or working with, let's say you have some kind of plug-in provider. You are responsible for making sure that their practices are up to snuff too. And they emphasize these self-regulatory efforts. This is an example of a self-regulatory effort. There's this website, Moms with Apps, and they're encouraging this kind of labeling for children's applications. So it's easy to read, easy to understand, and even your kids can understand it. My 6-year-old looked at this and said, but Mom, I kind of like ads when I watch apps. I wouldn't really like this. He didn't like that it was 3 and up, but he really didn't like that it had no ads. So this is just one example. Oh, he also didn't like that there's nothing you can purchase. But he doesn't know my password, so it's okay. That's him in the blue. He's a child, so I'm in charge of his privacy, and he can't consent to his participation in my program today. I did tell him, I showed him this, and I thought he'd be really excited. And he said, Mom, you're violating my privacy. And he asked me not to do it, but he's a responsible adult, so it's my decision. But if he was older, he would have a say. So he will not be in this presentation in the future when I deliver it on Mars when he's older. So, children's privacy, COPA. COPA's been around for a long time. COPA has to do with kids. Kids means kids under the age of 13. And it's not just if your site's a kid's site, it's if you know that kids are using your site. And it has to do with actually collecting information from kids. Collecting is an area that they've updated, and we'll talk about that. But COPA had not kept up with the times. Personally identifiable information, the definition has now been updated to include things like the IP address, the other persistent identifiers, excluding those for internal operation or maintenance. That's an interesting exclusion that was made, and that was made as the result of lobbying by advertising networks. So internal operation includes advertising purposes. So there's kind of a big loophole still. But especially because geolocation is something that they hadn't thought of and is a big part of apps today, it's important to keep in mind that COPA may apply to your site, even if it's not typically a kid's site. I said that they updated collecting. It used to be that collecting was like, here's your form, sign up, type in your name, and enter. Now there's that, but there's also, if they've these message boards and chat boards, that's collecting information. But again, they built in an exception, which is a good one, that if you have somebody monitoring the site and quickly deleting any personally identifying information, then you're good. You can have these chat boards without necessarily COPA kicking in. And also cookies, passive tracking, that's collecting now. So I went through that already, but the requirements. So let's say COPA does apply to you. It's not a huge deal if it applies, but it's important to know that you're going to have a privacy policy for sure if it does apply to you. You're going to give information upon request and have a certain number of security procedures that are probably pretty reasonable. But again, the big part of this is the notifying the parents, getting parental consent. It used to be that you had to send an email and get something back. It was called the email plus method. And they've kind of moved with the times a bit now. I think the PDF forms, okay, that's something. But what I think is pretty cool is the consent in connection with credit card payment. That makes it a lot easier for compliance purposes. Is it hot in here? I don't know. I may need to stop my presentation soon. Oh, wait. No, it may just be Bieber fever. I'm not just crazy. Bieberfever.com got in trouble under COPA very recently. So did Rihanna, but it's more fun to say Bieber fever. In the case of Bieber fever, here's what they did wrong. They didn't have any parental consent mechanism. Kids could join the fan club, create the profiles, post, all these things. And they got $1 million civil penalty. Don't be Bieber fever. Thank you very much. I'm going to stick around for some questions. I don't know how much time I have now, but I will be here this afternoon. Oh, I'm done.
Yeah, well, okay, I was going to say, if anybody does have any questions, as she said, she'll be around. Maybe find her in one of these areas out here, or maybe back in the workshop area. We do have to get the other panel in.
Absolutely. Thank you so much.
Thank you.
If you didn't